Arpan Banerjee. I am a research scholar at the Department of East Asian Studies, University of Delhi, and academic counselor at IGNOU. And I welcome you all to my learning session. I have been teaching you the paper Administrative System at State and District Levels, and the code of this paper is BPSC 134. So let us begin today's class. So far in this paper, we have discussed the first unit that dealt with the evolution of administration in India at the state and district level, and as part of that, we discussed the evolution of administration in ancient India, that is under the Mauryan Empire, the Gupta Empire, and then afterwards we had discussed the evolution of administration in India during the medieval period, and as part of that we had discussed the evolution of administration at the state and district levels uh, during the Mughal period, during the Mughal Empire's rule, and afterwards we had also discussed that how the administrative apparatus evolved in India under the British Raj, and how many elements from the British administrative apparatus and the British administrative system, they continued to exist even after independence, even after 1947. So we discussed the aspect of continuity and change in administration as well at the state and district level. So and as part of the block 2 that we have been discussing, uh, we have discussed the unit 2 of the block 2 that pertained with constitutional profile of state administration. Afterwards, we discussed the organization and function of the state secretariat, followed by the patterns of relationship between the secretariat and the directorates at the state level that we have discussed. And we have also discussed the State Service and State Public Service Commission as well. And also, we have discussed the State Planning Board also. And the State Finance Commission is also something that we have discussed in the last class. The functions of the State Finance Commission, the organization of the State Finance Commission, all these things we have discussed in detail in the last class. And in today's class, we are going to discuss the State Election Commission. And afterwards, we'll discuss the Lokayukt and the judicial administration in India. So let us begin today's class by discussing State Election Commission. So the State Election Commission in all the states of India, the State Election Commission are headed by a State Election Commissioner. So all the states of India have a State Election Commission, which is for the purpose of holding and organizing the local level elections, that is the panchayat elections and the election to the municipalities. So the rural local bodies elections and the urban local bodies elections are conducted by the State Election Commission. However, the elections for the State Legislative Assembly, they are conducted by the Election Commission of India. All right. So in all the states, there is a separate State Election Commission, and these State Election Commissions, they are headed by a State Election Commissioner who is appointed by the governor of that particular state. However, there are some states like Punjab where there is also a provision for the appointment of a Deputy Election Commissioner as well, along with the State Election Commissioner. And in most of the states, we observe that a retired civil servant or a retired judge is mostly appointed as election commissioner. So now let us discuss the post of election commissioner, which is a very important aspect of this unit. So the governor, by a notification in the official gazette of the state, appoints the State Election Commissioner, and the State Election Commissioner has to be an officer of the state government who is not below the age of 55 years, and the rank of that officer should be that of financial commissioner or of principal secretary to the state government. And and that person should have served at that post for at least 2 years. And the governor can also, as we've already discussed, appoint a retired judge of the High Court or as a state election commissioner. And also, as we discussed, that in some states there is a provision for deputy election commissioner as well. So the state government appoints one or more than one deputy election commissioners to assist the state election commissioner in discharging her duties. And as we've seen, there are states like Punjab who appoint deputy election commissioner as well. And there are other election officers along with the state election commissioner and the deputy election commissioners. Now, who are these officers? Let us discuss. The first such officer is the district electoral officer. So there is a district electoral officer for each district, and that district electoral officer is under the superintendent's direction and control of the state election commissioner. And at the district level, what we see is that the district electoral officer, the main function of that officer is to supervise the preparation, revision, as well as correction of electoral rolls. So that is the main function of the district electoral officer. And there are other electoral officers as well, such as the electoral registration officer as well. So the electoral rolls for each panchayat and municipality, they are prepared by the electoral registration officer. And so the main function of the electoral registration officer is to prepare and revise the electoral rolls and to also aid the district electoral officer as well. These are the main functions of the electoral registration officer. And an electoral registration officer also employs persons for the preparation and revision of electoral rolls for the panchayat and municipalities. And also for every constituency, there is a returning officer. This is a very important official. And for every election to fill seats in the panchayat or municipalities, the state election commissioner, in consultation with the state government, designates or nominates an officer of the state government or of a local authority as the returning officer. And along with the returning officer, there are one or more assistant returning officers as well. And afterwards, there are in the polling station, there are certain presiding officers as well. So the district electoral officer that we have already discussed, he provides a sufficient number of polling stations for every constituency, which are within her jurisdiction, and has to publish a list showing the polling station as well as the polling areas or the group of voters. So these are the officials that we have discussed. Now let us discuss the duties of the presiding officer, who is a very important official as far as state elections are concerned. As far as the State Election Commission is concerned, the presiding officer is a very important official. And at a polling station, the presiding officer ensures order as well as fair conduct of polls. And there are polling officers who assist the presiding officer in performing her functions. However, in states like Tamil Nadu, the State Election Commission is headed by an election commissioner who is not assisted by any deputy commissioner. Rather, he is assisted by the secretary. And the secretary is further assisted by a large number of administrative and technical staff. Now, who are the officers, who are the officials in these administrative and technical staff? So they are the chief administrative officer, the financial advisor and chief accounts officer. There is a principal election officer as well to the panchayats, and also there is a principal election officer to the municipalities as well. And along with them, there are legal advisor, public relations officer or PRO, as well as computer programmer. Now let us discuss some of the powers of the State Election Commission as a civil court. So the State Election Commission has been entrusted with certain powers of the civil court as well, while it is just in order to enable it to discharge its functions more efficiently. So the State Election Commission can summon and enforce the attendance of any person, and also examine that person on oath. So the State Election Commission can summon or enforce the attendance of any person, as well as examine that person on oath. And also the State Election Commission, just like a civil court, can require the discovery as well as production of documents or other material objects which can be producible as evidence. And also the State Election Commissioner has been the State Election Commission has been empowered to requisition public record or a copy from any court or office. And now let us discuss some of the powers to make rules for these functions that it has been entrusted with. So the State Election Commission has the power to make rules regarding the duties of the presiding officers as well as the polling officers. And also the State Election Commission can make rules regarding the checking of voters with reference to the electoral roll, and also regarding the manner in which votes are to be given in the constituency. The State Election Commission also has the power to make rules regarding the procedure that has to be followed in case of tendering a vote by a person representing himself or herself to be an elector. So these are the powers. Now let us further discuss some of the functions of the State Election Commission. So one very important function of the State Election Commission is preparation of electoral rolls for the panchayat and municipality election, and also it also performs the task of superintendence as well as direction and control of the state, the panchayat as well as municipality election. And also the State Election Commission is in charge of publicly notifying the elections, as well as appointment of dates and nominations also. And also deciding which person is eligible to be nominated a candidate, whether the nomination is valid or not. That is also decided by the State Election Commission, and which then publishes a list of contesting candidates, fixes the time for poll, as well as it also has the power to adjourn the poll in case of any emergency. And finally, it plays a very important role in the counting of votes. Now we also have an election tribunal. So some of the states, they have provided for the provision of an election tribunal at the state level. Now these are set up to take these are created to take up election related disputes. So in Punjab, we see that an election tribunal is constituted by the state government in consultation with the State Election Commission for each district, and also for certain subdivisional headquarters as well. And the state government, by notification in the official gazette of the state, appoints an IAS or provincial civil service class 1 or group A officer of the state government having adequate administrative, legal or magisterial experience as the presiding officer of an election tribunal. Now let us see some of the roles of the State Election Commission. So as mandated by the 73rd and 74th amendments, the state election commissions, they were established, and they are playing a very important role of strengthening the grassroots democracy in our country. And they are working on similar pattern of the election commission at the center, and they are enjoying more or less similar powers towards the conduct of free and fair elections to the local bodies. And to this effect, we can see that the state election commissions are performing a variety of functions and role. So their role may be categorized as regulatory, administrative, and quasi-judicial. And the State Election Commission They also have the power to control and regulate the delimitation of wards or territorial constituencies, and also regulate the election symbols, supervise the preparation of electoral rolls, check the election expenses, and other things. So these are some of the regulatory tasks that the State Election Commission performs, and these are very essential for the smooth conduct of election at the municipality and panchayat level. And towards the conduct of elections, a large number of preparatory tasks are also required to be performed with the help of its own staff, and also the staff of other departments at the local level. So these are performed by the State Election Commission, and this involves a variety of administrative and routine functions that are to be undertaken by the State Election Commission. And at the same time, the State Election Commission has to undertake certain quasi-judicial functions as well during the election process. In fact, in any election process, some disputes are likely to be raised by one or the other party, and the state election commissions, they are empowered to dispose of such election petitions or appeals in order to declare the election results in a timely manner. And as per the provisions of Article 243O, the interference by courts has been barred. So courts cannot interfere in the functioning of the State Election Commission. However, an appeal against the decision of the State Election Commission can be made in the High Court. And if there is an error or dispute of jurisdiction, or there is a violation of any constitutional provision, then an appeal can be made against the decision of the State Election Commission to the High Court, as per provisions of Article 243O. So we have discussed the State Election Commission, and now let us discuss the next unit of this block, that is pertaining to the role of the Lokayuk. So the Lokayuk is an anti-corruption ombudsman organization that has been established in the states of India at the state level. It functions at the state level, and its functions are similar to that of the Lokpal at the union level. So it is an anti-corruption ombudsman organization that has been set up at the state levels in India. And in this context, it has been set up under the Lokpal and Lokayukt Act of 2013. And this act came in the aftermath of the massive anti-corruption movement that engulfed the nation, which was spearheaded by the Gandhian activist Anna Hazare. So in the aftermath of that, the government of the day, the UPA government, it brought in the Lokpal and Lokayuktas Act of 2013. And this paved the way for establishment of the institution of Lokpal at the central level, as well as Lokayukt at the state levels. And these were set up to inquire into the allegations of corruption against public functionaries, as well as for other related matters. And as we all know that the phenomena of corruption, it has become one of the major causes for the tardy progress, for the very slow and shabby progress in the implementation of ambitious projects, as well as policies of the government. And they result in huge loss of revenue to the exchequer. So the existence of corruption, it has become ubiquitous with corrupt practices. And they have percolated to all levels of the economy, polity, as well as society. And the first Administrative Reforms Commission, which was set up in 1966, which gave its report in 1966-67, it said that it recommended the setting up of two special authorities, named the Lokpal and the Lokayukt, for the redressal of citizens' grievances. So it took almost more than 40 years to implement this recommendation of the first Administrative Reforms Commission. The first Administrative Reforms Commission, under the chairmanship of Morarji Desai, had suggested to set up Lokpal and Lokayukt in the 1960s. 1966 is when it gave its report. And the Lokpal and Lokayukts, they were constituted in 2013. So as we can see, almost 47 years after this recommendation. And the Lokpal and Lokayukt Act of 2013, it contains a mandate for setting up of these institutions of the Lokayukt through the enactment of a law by the legislature of respective states, and they have to set up this Lokayukt within a specified period of 365 days, that is 1 year. So this act was brought in 2013, passed by the parliament, and it became a law. And then states of India, they were required to set up, required to constitute, and they were required to enact a law in their respective legislatures within 1 year from the date of commencement of this act. And in this regard, this act provides the opportunity as well as the freedom to the states to decide the contours of the Lokayukt mechanism in their own states. So, in some states, we see that the Lokayukts are more empowered than other states, because it has been kept to the discretion of the state governments that how much power the Lokayukts will enjoy. So this is a major debilitating factor that has hindered the working of the Lokayukts at the state level. And the second Administrative Reforms Commission, which came out with its report in 2008, in its report on ethics in governance, it has recommended that the Lokayukt should be a multi-member body, and it should consist of judicial members as the chairperson, and also it should consist of an eminent jurist or eminent administrator with credentials as member, and as well as the head of State Vigilance Commission as ex officio member. So the chairperson of this Lokayukt should be selected from a panel of retired Supreme Court judges or retired Chief Justice of High Courts. And they should be selected by a committee consisting of the Chief Minister of that particular state, the Chief Justice of the High Court of that state, as well as the leader of opposition in the Legislative Assembly of that state. The Lokayukt, along with the Income Tax Department and the Anti-Corruption Bureau, they were envisioned to act as a safeguard in our democratic framework and also to help people to highlight corruption cases. So there is a discernible divergence in the patterns of the structure and role of Lokayukts in various states. So that I have already discussed. Now, to assist these Lokayukts as well as the Up-Lokayukts, the organization in Madhya Pradesh, if we see the case of Madhya Pradesh, that is divided into 4 functional wings. The first wing is the administrative and inquiry section of the Lokayukt. And this section is headed by a secretary who is a senior IAS officer, and it functions as the head of the department for an entire organization. Afterwards, we see that there is a legal section which is there to assist the Lokayukt and the Up-Lokayukt in dealing with legal matters and also conducting inquiries. And mostly officers who are of the rank of district judge, they are posted as legal advisors. And there is an officer of Chief Judicial Magistrate rank also, who is posted as deputy legal advisor, and these officers, they are sent on deputation from the High Court. Now there is a special police establishment also, which has been set up to aid the functioning of the working of the Lokayukt in respective states. And this special police establishment is constituted for investigation of certain offences which affect the public administration and those falling under provisions of the Prevention of Corruption Act, which is of course a central act. And this special police establishment, it is headed by the Director General, and who is of the rank of Director General or Additional Director General of Police in this case of Madhya Pradesh. And also there is a technical cell of the Lokayukt as well, which deals with inquiries of technical nature. And this technical cell is headed by the chief engineer, under whom there are executive engineers, assistant engineers, and technical assistants. Also, there are district vigilance committees. So, there are 7 divisional committees in Madhya Pradesh which inquire into the complaints that are referred to them by the Lokayukt or the Up Lokayukt. And afterwards, after inquiring, they submit a report to the concerned authority. Now, let us see how the Lokayukt is appointed. So, if we talk about the qualification and term of office of the Lokayukt, for the Lokayukt, judicial qualifications are prescribed in certain states such as Uttar Pradesh, Himachal Pradesh, Andhra Pradesh, Gujarat, Odisha, and Karnataka. However, there are no specific qualifications that are prescribed in certain states for the appointment of Lokayukt, and these states are the state of Bihar, Maharashtra, and Rajasthan. And the term of office which is fixed for the Lokayukt in majority of the states is of 5 years, or until that person is of 70 years old in the state of Himachal Pradesh. And the Lokayukt is not eligible for reappointment for a second term. At the state level, there is, as we have observed, there is no uniformity in the case of jurisdiction of the Lokayukt. And in this regard, the chief minister is included within the jurisdiction of Lokayukt in certain states such as Himachal Pradesh, Andhra Pradesh, Madhya Pradesh, as well as Gujarat, while the chief minister is excluded from the purview of Lokayukt in certain states such as Maharashtra, Uttar Pradesh, Rajasthan, and Bihar. And ministers and higher civil servants, they are included within the purview of majority of states, and they are included in the purview of Lokayukt in the majority of states. However, Maharashtra has also included former ministers and civil servants as well under the purview of Lokayukt. Now let us discuss some of the powers and functions of the Lokayukt. So if we talk about the supervisory powers of the Lokayukt, that is powers of superintendence over and to give direction regarding matters that are referred for preliminary inquiry or investigation. And also the Lokayukt has been entrusted with the power of search and seizure, as well as the powers of a civil court in certain cases. And the Lokayukt also has the power to utilize services of officers of the state government, as well as the power of provisional attachment of assets as well. And the Lokayukt has also the power to give directions or to prevent the destruction of records during preliminary inquiry, and it also in this context has the power to delegate. So the Lokayukt, it may direct that any administrative or financial power which has been conferred on it may also be exercised or discharged by its officer. Now, if we do a critical analysis of the role of the Lokayukt, what we see is that the reports of the Lokayukt, they show that the largest number of complaints have been regarding the departments of public works, health, irrigation, civil supplies, municipalities, as well as cooperative societies. And in this regard, sometimes genuine complaints which are filed by affected citizens and which are made to the state Lokayukt, they are rejected also many of the times for the want of jurisdiction, anonymity, or triviality. So this has been observed, and this has been a criticism of the Lokayukt's functioning as well. However, on the other hand, Lokayukt have complained that they do not get sufficient information from the government departments and as well as the state investigating agencies. As a result, complaints which are filed with Lokayukt are not cleared expeditiously, and citizens do not get speedy justice. So, after the conclusion of the 11th All India Lokayukt Conference, 16 Lokayukts, they sent the following recommendations to the government of India. Now, what were these recommendations? Let us discuss. So, the first recommendation was to make the Lokayukt the nodal agency for receiving all corruption related complaints. The second recommendation was to accord the Lokayukt jurisdiction of state level probe agencies, and also to bring bureaucrats under the ambit of the Lokayukt. So these are the three recommendations which 16 Lokayukts sent to the government of India after the conclusion of 11th All India Lokayukt Conference. And another such recommendation was to accord powers of search and seizure as well as powers to initiate contempt proceedings. And also there was a recommendation to provide administrative and financial autonomy to these Lokayukts in order to ensure better functioning, and also to bring NGOs which are funded by the state government under the Lokayukt's jurisdiction. So we have so far discussed two units today. First is the State Election Commission and its functions regarding the superintendence, supervision, and conduct of the elections at the local levels, that is the urban local bodies and rural local bodies elections. And we have also discussed just now the powers of the Lokayukt, the functioning of the Lokayukt in tackling corruption at the state level. Now, let us discuss the judicial administration, which is unit 10 of this second block that we are discussing, the judicial administration at the state and district level. So in India, we know that the judiciary, it occupies a very important place. And the constitution of our nation, it visualizes an independent judiciary to safeguard the rights of the citizens of this nation. And in a democratic polity, an independent judiciary, it is sine qua non to the effective functioning of the system. So if we want the democratic system to function effectively, we need to have an independent judiciary. It is indispensable. And also because the administration in our country, it has to function according to the law and constitution. And that is why the judiciary, it has a very important role to play in protecting the citizens against arbitrary exercise of powers by the administration at the union level and also at the state and district level. So in this context, Lord Bryce, who was who was an eminent jurist, he has said that there is no better test of the excellence of any government than the efficiency and independence of its judicial system. And here, judicial administration means the dispensing of justice according to law, especially through the functioning of a system of courts. So if you want to test the excellence of a government, you have to see whether the judiciary is functioning efficiently and independently or not. And if it is not functioning independently, if it is under the undue influence of the government, of the executive or the legislature, then we cannot say that the government is functioning in proper manner or in democratic manner. So having an independent judiciary is basically indispensable to the functioning of a democratic polity like India. And what we have observed, that an important feature of the judicial system in our country is that we have a single unified judicial system. Unlike the United States of America, which does not have a unified judicial system, in India, we have a single unified judicial system. And the whole system of courts taken together, they are referred to as the judiciary. And that is why we have the Supreme Court has jurisdiction over all subordinate courts, over the High Court as well as the district level courts, as well as all the rest of the subordinate courts. However, in the United States, the Supreme Court of United States is not empowered to do that, because the United States does not have a unified judiciary. The Supreme Court of United States, it is not the highest court of appeal. All right. However, in our country, the Supreme Court is the highest court of appeal. Before independence, it was the Privy Council of the Emperor, but after independence, it became the Supreme Court. And also in the United States, the Supreme Court, it only deals with matters which are there in the union list, and also it deals with matters relating to the disputes between the union and the states. However, it is not empowered to tackle or to deal with cases which arise at the state level. At the state level, only the federal courts of the states, they can deal with them, of the respective states. However, in our country, that is not the case. And if we compare the legislative and executive system in our federation with the structure of judicial system, we find that there is a difference. And we have separate legislative and executive authorities for the center and the states. And the functions of these separate legislative and executive authorities, they are also divided. There is clearly divided and clearly enumerated by the Constitution of India. However, our judicial system is different. So the judiciary in our country, the judicial system in our country, it runs like a pyramid, from the subordinate courts and district courts at the local level, which are there at the bottom of the pyramid, to the High Court at the of every state, to the Supreme Court of India, which is at the top of the pyramid. So the judicial system, it is like a pyramid in our country, with subordinate and district courts at the local level forming the base of the pyramid, followed by the high courts at the state level, and finally at the top of the pyramid there is the Supreme Court of India, which is the custodian of the Constitution of India. The Supreme Court in our country, it occupies the highest position in the judicial hierarchy of India. And the Supreme Court of India, it comprises of the Chief Justice as well as other judges who are appointed by the President of India. The Supreme Court has 3 areas of jurisdiction. Now, what are these 3 areas of jurisdiction? Let us see. The first area is that of original jurisdiction. The second is that of appellate jurisdiction. And the third is that of advisory jurisdiction. Now, let us first discuss the original jurisdiction of the Supreme Court of India. Now, the original jurisdiction of the Supreme Court of India, it pertains to disputes between the government of India and one or more states, and also to claims of infringement of constitutionally guaranteed fundamental rights. The Supreme Court's appellate jurisdiction, it extends to 4 types of cases in our country. Now, what are these 4 types of cases? These 4 types of cases are constitutional, civil, criminal, and special leave petition. So these are the 4 types of cases over which the Supreme Court's appellate jurisdiction extends. And in these types of cases, under certain conditions, appeals may be made from any state high court to the Supreme Court, which we see most of the times. And also the Supreme Court's advisory jurisdiction, it pertains to matters referred for the purpose of seeking advice. Also, the President of India may refer a question of public importance for the advice of Supreme Court. Now let us discuss the high courts. So the high courts, they are in the second level of judiciary. And ordinarily in our country, every state has a high court. However, we see that two or more states may also have one high court. For example, the Punjab and Haryana High Court, which is situated in Chandigarh, which is the common high court for both the states of Punjab and Haryana. The High Court consists of a Chief Justice as well as other judges appointed by the President of India, as well as the High Court of the states. It also has three types of jurisdictions similar to that of the Supreme Court, and these are original jurisdiction, appellate jurisdiction, as well as administrative jurisdiction. Now, however, one important thing that we need to remember is that the the appellate jurisdiction of the High Court is in terms of rights, it is broader than that of the Supreme Court. So we can only appeal directly to the Supreme Court in case only our fundamental rights have been infringed upon. So Article 32, which is regarding right to constitutional remedies, it empowers every citizen of India with the right to appeal directly to the Supreme Court in case their fundamental rights are infringed upon. However, if our legal rights are infringed upon, for example, right to property, which once upon a time used to be a fundamental right, but it is now a legal right. So, if our legal rights are infringed upon, then we cannot directly approach the Supreme Court. However, in case of violation of legal rights, a citizen can approach the High Court of his or her respective state. So that is why we see that the appellate jurisdiction of the High Courts, it is broader than that of the Supreme Court. And so now let us discuss the original jurisdiction of the High Court. So among its original jurisdiction, the High Court has the power to issue warrants regarding fundamental rights of citizen, and it also has the jurisdiction to try civil and criminal cases. Now, if we see its appellate jurisdiction, now that includes the authority to try appeals about civil and criminal cases from the lower courts. So the appeals which come from the district courts to the High Court has the power to try such appeals which come to it from the lower courts regarding civil and criminal cases. And if we talk about the administrative jurisdiction of the High Courts, they are related to the superintendence over the subordinate courts, that is the district courts and other courts. Now, in our country, judicial intervention in administrative activities, they are confined to only these following cases. Now, the first case is that of lack of jurisdiction. So, if any public official or administrative agency acts without or beyond his authority or jurisdiction, in that case, the courts can declare such acts as ultra vires, that is null and void. For instance, according to administrative rules and procedures, in all organizations, the competent authority is identified for taking decisions and actions. And if someone who is not a competent authority takes such decisions and acts, then the judiciary can declare such acts as ultra vires. So the judiciary can intervene in case of lack of jurisdiction. If a person does not have the jurisdiction to act or take decisions, is not the competent authority, and despite that is taking those decisions or is acting on that behalf, then the judiciary can declare such acts as ultra vires or null and void. The second instance, the second case in where the judiciary can intervene is regarding error of law. Now, this category of cases, it arises when the official misconstrues the law and imposes upon the citizen such obligations which are absent in the law. So, if an official is misconstruing the law and is imposing certain obligations upon the citizens which are absent in the law, this is called error of law, and this is called misfeasance. So, in case of this misfeasance, in legal terminology, the courts, they have been empowered to set right. They have been empowered to intervene in case of legal misfeasance. In case the officials are misconstruing the law and imposing upon citizens such obligations which are not there in the law. The third case, in the third instance where the judiciary can intervene, is regarding cases which are related to the error of fact. Now, if we discuss this category of cases, these are a result of error in discovering cases and actions which are taken on the basis of wrong assumptions. And any citizen who is adversely affected by this error of judgment of public officials, they can directly approach the court for redressal of their grievances. So, we have discussed lack of jurisdiction, error of law, and error of fact. Now, there is another instance in which the judiciary has been empowered to intervene. That is regarding error of procedure. And in such cases, due procedure is the basis of governmental action in a democracy. And when we talk about responsible government, it means a government by procedure. And procedure in administration, it has a very important role because it is procedure only which ensures accountability, openness, and justice. And that is why public officials, they must act in accordance with the procedure which is laid down by law in the performance of their administrative activities. And if the prescribed procedures are not followed, then the intervention of the courts, they can be sought. And also the legality of these administrative actions which have been done, which have been conducted without following the prescribed procedure, that also, the legality of the administrative action, that also can be put under question mark. So, error of procedure is the fourth such instance in which the judiciary can intervene. And the judiciary can also intervene in case of abuse of authority. So, if a public official, while exercising her authority vindictively, if a public official exercises her authority vindictively in order to harm a person, or if a public official uses the authority that has been given to her for personal gains, then the person who is affected by such abuse of authority can seek legal intervention, can seek intervention of the judiciary. And if we talk about this in legal terms, this is called malfeasance. So we have discussed misfeasance. This is called malfeasance. Abuse of authority is termed as malfeasance. And the courts, they can intervene to correct the malfeasance of administrative acts. Now, judicial review is also a very important part of any effective democracy, and in our country, judicial review, as per the Kesavanand Bharati versus Union of India case of 1973, which was pronounced on 24th April 1973, as per that case, the Supreme Court of India held that judicial review is a part of the basic structure of the Constitution. That is, the parliament cannot amend the constitution in such a way so as to remove this provision of judicial review from the constitution. So judicial review is a part of the basic structure of the constitution, according to the Supreme Court, and it is indispensable to ensure the independent functioning of the judiciary. So the judicial review, it implies the powers of the court to examine the legality and constitutionality of administrative acts of officials, and also to examine the legality and constitutionality of executive orders as well as laws which are passed in the state legislature, uh, which are called legislative enactments. So they not only include the laws, but they also include the executive orders and also the administrative acts of officials. So all these fall under the purview of the judicial review. And earlier, such acts which were included in the ninth schedule of the Constitution of India, which had been inserted by the First Amendment, earlier such acts were outside the purview of judicial review, and mostly they included acts related to the abolition of zamindari and relating to land reforms. However, the Supreme Court, in its judgment of Kesavanand Bharati versus Union of India, which it delivered on 24th April 1973, the Supreme Court clearly stated that even acts which are there in the ninth schedule, they are also in the purview of judicial review. And the Supreme Court further reinstated this position in the I.R. Coelho versus State of Tamil Nadu case in 2009. So now everything which is there in the constitution and every law enacted by the government, the state governments as well as the union government, every executive order issued by the union and state governments, as well as administrative acts of officials at the union as well as provincial level, they are all under the purview of judicial review. And judicial review, that is why it has become a very important method of judicial control. And this doctrine of judicial review, it prevails in those countries where the constitution is supreme. For example, in countries like United States of America, in India, also in Australia as well. However, if we talk about India, judicial review is restricted by certain provisions of the constitution as well as of an act which declares finality of administrative decisions in particular matters. So judicial review is not always supreme. For example, if we see the conduct of the functioning of the election commissioner, while the election commissioner is the election commission of India is conducting the state legislative election, assembly elections or elections to the parliament, then the judiciary cannot intervene in its functioning. However, later on, petitions can be filed to the judiciary, but it is only after the election has been conducted, not while the election is going on. And there are certain extraordinary remedies also relating to the judiciary. Apart from the methods of judicial control that we have already discussed, there are certain extraordinary remedies also, which are the writs. Now, these writs are regarding are habeas corpus, mandamus, prohibition, certiorari, as well as quo warranto. And these writs, they are called extraordinary remedies because the courts, they grant these writs except the writ of habeas corpus in their own discretion. And these writs are a matter of right, and that too when no other adequate remedy is available. So these are mentioned in Article 32 of the Constitution of India, as well as Article 226. So a writ is an order of the court which enforces compliance on part of those against whom the writ is issued. And in India, these writs are available under the provisions of the Constitution, that is under Article 32 for the Supreme Court and under Article 226 for the respective high courts. And while the Supreme Court is empowered to issue these writs or orders or directives only for the enforcement of fundamental rights, the high courts, they can issue these writs not only for the enforcement of fundamental rights, but also for other rights such as civil and legal rights. So the writ jurisdiction of the high courts is broader than that of the Supreme Court. Now let us discuss some of the limitations of judicial control over administration. The first limitation is regarding the unmanageable volume of work. And the judiciary has a huge volume of work. There are lakhs of cases that are pending before the Supreme Court as well as the high courts, and that is why the judiciary is not able to cope with this voluminous work. And in a particular year, the judiciary is able to deal with only a fraction of the cases which are brought before it. And also what we see that judicial control in our country, it is of a post-mortem nature. In most of the cases, the judicial intervention comes only after enough damage has already been done by administrative actions. And even if the courts, they set right the wrong that has been done, there is no mechanism in our country to redress the trouble that the citizen has already undergone. Also, there is an issue of prohibitive costs. Now, the judicial process is very costly and only the rich can afford it. So, there is some truth in this criticism of the pro-rich bias in judicial system in India, and as a result, only the rich are able to seek the protection of court from administrative abuses. And also the procedure is also very cumbersome, very lengthy and very tedious, and many legal procedures are beyond the comprehension of the common man, and that is why the procedural tyranny, it frightens many from approaching the courts. Even though the procedures have a positive dimension of ensuring fair play, too much of it it negatively impacts the whole process. And however, with the emergence of public interest litigation, the courts, they have been indulging in social action groups, so to make the judiciary more accessible to the deprived, the poor, as well as victims of social oppression. And the concept of locus standi, that also has been done away with. Now, not only the person who has been directly affected can approach the court, but a person can approach the court on behalf of others who are not been able to approach the court. So this has facilitated social action groups as well as conscious individuals to enable the courts to take cognizance of different forms of injustices that are done to the poor. And so that is why it is being said that the courts, they must shed their character as upholders of the established order and the status quo. That must be done, and that is why Justice P.N. Bhagwati, while championing the public interest litigation, he said that for the first time, the portals of the court are being thrown open to the poor and the downtrodden, and that is why Article 39A in our Constitution has, which is part of the directive principles inserted by the 42nd Amendment, that has now made legal aid a part of the Constitution. That is helping those who do not have the financial resources to reach the judiciary, to enable those to reach the judiciary in case they are suffering from social justice or their rights are being violated. And finally, we have certain Gram Nyayalayas which have also come up, which has been established under the Gram Nyayalayas Act of 2000 Act, and they have been established for speedy and easy access to the justice system, especially in rural areas. And the major aim is to provide inexpensive justice to the rural people at their doorsteps. And we see that finally 221 functional Gram Nyayalayas have been established. So in this class today, we have discussed the State Election Commission as well as the Lokayukt, and finally we have discussed the judicial administration in India. So thank you everyone for attending this class, and in the next class we'll discuss the next unit of this second block. And today we have discussed in detail the State Election Commission, in conducting state level elections, in the local bodies. Then we have discussed the Lokayukt, and finally the